Welcome, everybody. I'm Larissa Rue. I'm one of the credit investigators in the credit branch at the Commission. As Paul mentioned, today I'm going to be talking about disclosure. As you may know, disclosure is all of the important information that a borrower needs to know about the loan before they enter the arrangement and if things are changed. It's an important thing for lenders to get right because for borrowers, they need to be able to make informed choices and understand their rights. For lenders, the consequences of getting it wrong are significant. And for the Commission, we're continuing to see examples of disclosure that are wrong. So what are we going to cover? First, the law. I'll take you through the law around disclosure, including what the lender is obligated to do when arranging a new loan, during the contract term, and when changes are made to a contract. I'll also take you through changes to lender obligations in relation to disclosure from 1 December 2021, requesting documents from lenders, standard form and costs of borrowing disclosure, and finally the consequences of inadequate disclosure for lenders. But before we begin, I'm going to be covering quite a lot of content and some of it quite quickly. All of the information is available to you in our Red Flags Guide for Consumer Advisors helping people in debt. These are on our website, and Chapter 5 deals with disclosure. All right, let's begin. So the law, for a starter, the CCCFA applies to consumer credit contracts. A consumer credit contract is one step above a standard credit contract, and it requires that a few extra conditions be met. Here are some key elements of a consumer credit contract. Just note that I've abridged this for our presentation. The Act is much more detailed. The borrower must be a natural person. For example, it cannot be a business. The loan must be wholly or predominantly for personal, household, or domestic purposes. The contract must provide for interest charges, credit fees, or a security interest, and the lender must be in the business of providing loans. Next, when a lender arranges a new loan, they have obligations under the CCCFA as part of initial disclosure. Lenders must provide initial disclosure information to a borrower before the contract is entered into. The mandatory information is set out in Schedule 1 of the CCCFA, and the regulations set out model disclosure statements, but lenders don't have to use them. As long as they have all of the required information contained in their initial disclosure documents, they're compliant. So if lenders use a disabling advice, sometimes called an immobilizer, there is some extra information that they must disclose. I know that this is quite topical for mentors at the moment, so I'll just run through quickly what information they need to disclose. 1, how the device functions. 2, when the device might be activated. And 3, how, if the consumer goods are required in an emergency situation, the debtor may obtain use of the goods. And finally, until lenders have provided the required initial disclosure, they are not able to enforce the contract. This means that they can't charge any costs of borrowing. Lenders also have to provide continuing disclosure to borrowers, which are the loan statements, and these must be provided at least every 6 months or 45 days if it is a revolving credit contract, for example, a credit card. There is one other type of disclosure that lenders must make during the contract term, and this is when the contract is varied. I'm sure that you'll be familiar with this type of disclosure if you've negotiated lower repayments for your client and extended the term of the loan. These changes can be agreed, or a lender may be able to change the contract themselves in certain circumstances. When agreed changes need to be made, lenders are expected to provide full particulars of the change. This means the change and its effect. For example, if lower repayments are agreed, this also means that the term of the loan is extended, so the borrower may end up paying more interest. For timing, lenders need to provide disclosure before the agreed changes take effect. This includes if the change is due to a hardship application, although there are a few exceptions for this under the CCCFA. I now want to talk about the new disclosure obligations that took effect on 1 December 2021, and they focus on the following areas: financial mentoring services. lenders are now required to provide information about financial mentoring services in a prominent manner to the borrower if the borrower has defaulted in payment or caused their credit limit to be exceeded, makes a hardship application, and/or the lender declines a high-cost loan application. We recently heard of some confusion over what information lenders must provide borrowers about financial mentoring services. We took the opportunity to provide some clarity around this for lenders at the recent seminars that we held for them earlier this month. This is what we told them. If after December 2021, your borrower defaults, exceeds their credit limit, or makes a hardship application, or you decline a high-cost loan application, then you must disclose 1, a statement about the availability of free and confidential advice from an independent service. 2, the name of a building financial capability service funded by MSD that provides such a service. And 3, the contact details for the service. It should be a financial mentoring service that is local to the borrower, or a national one if no appropriate local one is available. Finally, if lenders are referring the borrower to a national service, it's fine for them to refer to FinCap or Money Talk specifically. Lenders must also provide information about dispute resolution services to the borrower if they make a hardship application and/or complain about enforcement action, for example, debt collection. That's a nice segue into the new rules around disclosure for debt collection. From 1 December 2021, before debt collection starts, debt lenders are required to provide certain information. You can find this in the Red Flags book on page 19. If you are helping a client with debt collection, you should now expect to see the following disclosed. Information that will help the borrower identify the credit contract, a statement about the debt itself and any extra fees charged if known at the time, information about the debt collector, a statement about hardship rights, and information about free and confidential advice being available from a building financial capability service. I'm sure that that's a welcome change, but remember that that's only for debt collection on consumer credit contracts, not for debts like rent or power bills. If lenders have websites, they must ensure that their standard form contract terms and their costs of borrowing are clearly accessible and easy to find. This is handy to know if you want to know the standard interest and fees that any lender charges. That brings me nicely into request disclosure, which can help you if you need a copy of the actual contract that your client signed. We know that sometimes financial mentors have trouble requesting documents from lenders. When you request disclosure, for example, a copy of the loan contract or statement, the lender must provide that information within 15 working days in most circumstances. A fee may apply. If you've asked the lender and 15 days pass with no reply, this is a red flag. In this situation, you could complain to the lender and, if necessary, their dispute resolution scheme. Breaches of request disclosure are an infringement offence, and the lender can be liable for fines of up to $30,000 for a body corporate if they're taken to court. But what about situations where your client is a co-borrower and the lender refuses to provide the information on request, or asks you to get a privacy waiver from the other person? Well, Section 24 of the CCCFA states that every debtor or guarantor under a consumer credit contract may request copies of the documents. So our view is that each borrower can request it individually and lenders need to comply. When engaging with the lender, just point them to that provision and stress the words every debtor. If they still don't comply, let us know, and you can also call their DRS who can intervene immediately to get an outcome for your client. Disclosure is really important for lenders to get right. Borrowers need the information required by the law to make informed choices and know what they're getting into. And if lenders fail to provide it, there are significant civil and criminal consequences. So let's talk about some of those consequences. Let's start with the fact that If lenders don't follow the requirements for initial and variation disclosure, they can't enforce the contract until they have made the correct disclosure. They can't recover or retain any interest or fees for the period of non-compliance. What this means is that a lender will need to return all of the fees and interest collected so far to a borrower if its disclosure is not up to scratch. And once correct disclosure has been made, the lender can't go back and recharge the interest and fees for the non-compliant period. A second and significant consequence of getting initial disclosure incorrect is that the borrower can cancel the contract without penalty, although some fees and interest may need to be paid depending on the contract. The court can also make a wide range of other orders to remedy a disclosure breach. So orders for extra damages, refunds, or compensation, and repeated non-compliance could potentially result in an order banning a lender. Any orders made by the court will also be taken into account in reassessing an existing certification status or considering future fit and proper certification applications. So getting disclosure wrong is pretty serious. And then there are the infringement offences. The Commission can issue an infringement notice, which can be up to $2,000 if it has reasonable grounds to believe that a person has committed an infringement offence. That brings us to the end of our whistle-stop tour of disclosure. I hope that it was useful. Just a reminder to make sure that you read and take on board the Red Flags, a credit law guide for consumer advisors helping people in debt, as updated last year.